In this video, we're going to go over what specific factors a court will take into account when deciding whether to grant or not to grant your expungement petition. So what the law says is an expungement is not a right, that a judge has the sole discretion in deciding whether your expungement petition will be granted or not be granted. And realistically, what will a court take into account if they decide to not grant your petition would be, number one, obviously, if the DA objects. Number two, maybe the judge was the judge on your case and they didn't like your attitude, or the judge disagreed with the jury's decision. Would be something they may have caused them to not grant the expungement, or may believe that what you did was not illegal. However, it veered on the line, and therefore employers need to know. Again, it's sole discretion of the judge. If the DA objects, though, there is a statute that explains 10 different factors that the court is to take into account when deciding whether to grant the expungement petition. And what those are is, number one, nature and seriousness of the offense committed. Was it a Class A felony? Was it a lowly misdemeanor? Number two, the circumstances under which the offense occurred. Were you aiding and abetting the person and not necessarily the main target? Were you the main target? Number three, the date of the offense. Did this happen 20 years ago and you haven't had any issues since then, or was it recent? The age of the person when the offense was committed. Were you 19 years old and had been in any trouble since then but weren't granted youthful offender? Were you 45 years old and you should have known better? Whether the offense was an isolated or repeated incident. So, for instance, if it was a theft case, did you do it over and over and over again, but it was just charged as a theft one? Or was this just a one-time thing where you got caught smoking pot at a party? The court will take those into account. Other conditions which may have contributed to the offense, that's just going to be sort of a catch-all. Your probation or parole record just shows how well you did on probation and parole. Did you pass with flying colors, get all your money paid, or did you get revoked? Did you fail to pay your money timely? Whether the offense was dismissed as part of a negotiated plea agreement and the petitioner pled guilty to another related or lesser offense. So let's say that you were charged with trafficking and possession and you pled guilty to the possession and the trafficking was dismissed. The court can say, hey, look, no, this was obviously part of a plea agreement. I want that trafficking to still be on your record. Evidence, number 9, is evidence of rehabilitation, including good conduct in prison or jail, good conduct in the community, counseling or psychiatric treatment received, acquisition of academic or vocational schooling, successful business or employment history, and the recommendation of his or her supervisors or other people in the community, or rehab, for instance. And then another catch-all, any other matter the court deems relevant. So those are the factors the court will take into account when deciding your expungement petition.